Right, we've had a couple of minutes after 10. I'm going to kick off in just a second. So before I do that, I'll just introduce myself. So hello, everybody. My name's Guy Bradenkamp from DAC Beechcroft. Apologies for those of you who were expecting Sarah George to be delivering this. Sarah's unfortunately indisposed, so I've stepped in to do this in her absence. I'm getting an echo on my audio, so can I ask if anyone's got their speaker on, if they could mute that, please, because it's going to interfere with the audio at my end. And I think generally, if you could keep yourselves on mute, please, during the presentation, that would be fantastic. Okay. So I haven't done one of these talks before to the HPMA on diversity. I gather we do one like this every year. Hopefully this will be different enough from the previous ones that you've seen to make it interesting and stimulating. Do please interrupt me and ask questions if you have any as we go through, but there will be some dedicated time for a Q&A at the end, so that anything we've raised can be opened up for discussion in the group or with me, or however you want to deal with that. So without further ado, I will start moving the slides on so we can get cracking with the presentation. So what we are looking to do today is really summarized on this slide. So a couple of issues really in broad terms, one of which is to do with increasing representation, which I suppose is what the whole theme of delivering diversity is about. So it's all of those things about the importance of diversity, equality, and inclusion, some of which, of course, will be perfectly obvious to all of you, but there'll be, I hope, some useful insights in there as well. And then some more sort of hard-edged legal points about eliminating discrimination in practice, including some of those points about conscious and unconscious discrimination, positive discrimination, some issues about disability discrimination in particular, and some of the tricky issues you find in practice with discrimination. So, as I say, I apologize if some of the opening remarks I'm about to make are pretty obvious to you all, but I think it's useful for us all to, I think, to set the scene so that we know where the rest of the presentation is coming from. Right, so equality, diversity, and inclusion. This slide is really just there to show that, the way in which they fit together. They all, of course, are part of the same environment that we're hoping to create in the workforce, where people are treated equally, and we are operating inclusive workforces, regardless of the diversity of the staff that we employ. And again, none of this stuff is controversial, but it's useful just to set the framework, as I say, for what we're operating in. So equality is the state of being equal, especially in respect of rights, status, rights, or opportunities, again, entirely uncontroversially. And diversity is the recognition of the differences between staff, for example, because of their race, religion, age, sex, or sexual orientation. And I suppose the reason why it's worth flagging those things up is that equality is often misunderstood as an obligation to treat. Sorry, is someone asking a question? No, so that's fine. So equality is often misunderstood as the need to treat everyone the same. And that is a perfectly good starting point. But of course, there is a nuance in that, in the sense that in recognizing diversity, you will need to understand the needs of various people. And particularly here, we're talking about people with protected characteristics under the Equality Act, because some people will have different needs and different expectations about the way they're going to be treated. And the whole equality, diversity and inclusion agenda is about respecting those differences and understanding how to manage a diverse workforce, and that then brings in the question of inclusion and the right of all those people, regardless of their diversity in terms of the various different groups they might fall into, their right to respect and appreciation of their value, regardless of their differences. So we're not necessarily ignoring their differences, but we need to accept them and understand how we can manage a workforce which includes people with those differences and manage them accordingly. All right. A diverse workforce is important because it introduces a broader skill set into the workplace, different experiences and points of view of different people from different backgrounds. In the health service in particular, it helps us to serve and treat a diverse range of patients. There are some difficulties with that, of course, and we've certainly come across cases as employment lawyers where, for example, hospitals are faced with patients who are racist, unfortunately, and they refuse to be treated by doctors or nurses or anybody else from an ethnic minority. And there can be very difficult issues which are thrown up by individuals whose behavior is not within your control as HR people or as hospital managers, and understanding how to deal with those situations sensitively and recognizing the patient's point of view, but also respecting your staff and their perfectly justified requirement to be treated in a way which doesn't discriminate against them on the basis of their ethnicity or anything else. And part of the reason why that's so important is that it really doesn't take very much in practice for staff who are from any kind of minority group or with a protected characteristic to feel that they are not in the tent, if you like. They don't feel properly included. They don't their views and their outlook is not valued. So very much the challenge for large organizations in particular is recognizing that diversity of the workforce that you've got and making sure as far as you can that everyone feels able to contribute to a positive working environment, and the culture in the organization is inclusive in the sense that people don't feel left out. As you'll see later on, the reason why that can be very difficult is because if someone feels left out or marginalized or bullied or harassed or in any other way treated less favorably than they see their colleagues being treated, that might of course have nothing at all to do with any protected characteristic, but that doesn't mean that they won't feel that it does. And once you get into that sort of position, and if you're not managing your workforce effectively, inclusively anyway, it makes those complaints from those employees, those grievances and concerns that they might raise, very much more difficult to deal with, because once they get the impression that their treatment has got something to do with their race or their gender or their sexual orientation or whatever it might be, it's very then difficult to row that back. So that's why it's important for organizations to promote this environment of diversity and inclusion and make some noise in the workplace about how the organization respects those things. And that's the way you can attract new staff into the organization from various protected groups and retain them and enhance your organization's reputation as an employer. One of the things we do, obviously, as employment lawyers is deal with employment tribunal claims. And I can safely say that there is no kind of employment tribunal claim that is more damaging and disruptive and upsetting than a long and difficult discrimination claim from an employee who feels that they've been badly treated over a long period of time. Because those kinds of claims tend to involve a lot of people, because if there's been a formal process involving that individual over a long period of time, there will be a pretty large cast list in that employment tribunal claim, because everyone will need to give evidence about what they've done and why. And as I say, they can be really traumatic for everyone involved, the claimant and all the witnesses. And of course, the risk for the organization of being found ultimately by the employment tribunal to have discriminated against someone is really serious. And so I'm not suggesting that you look at all of these issues through the lens of an employment lawyer, but certainly that is one of the issues you need to think about as a potential worst case or nearly worst case arising from all of these things. So just an excerpt from the NHS People Plan. I'm sure you've all read that and have it by your bedside for light reading. But it does make it very clear that the NHS was established on the principles of social justice and equity, and that very much includes thinking about how we treat our colleagues, and in particular colleagues from minority groups. So there is very much an agenda in the NHS from the highest levels of people management to promote this idea that we are trying to achieve inclusion and equality in our workplaces. So how does discrimination arise most often? And again, I'm looking at this partly from the position of an employment lawyer, because that's what I am, but also just in terms of managing people and being sensitive to these issues coming up. And I suppose the starting point, which has to be said, is that it's very rare in practice, in our experience of managing these things, that anyone intends to discriminate against someone because of a protected characteristic. It certainly does happen, but in terms of the legal cases of discrimination that we get to see, they are normally about different perceptions of people's behavior and the motivations behind that behavior. And one way of describing this is often unconscious bias or unconscious discrimination. And some people are very uncomfortable with the idea that you can discriminate against people unconsciously. Some people think that's a ridiculous idea, but actually, from our point of view as lawyers who deal with advising on complaints and grievances about this area, I think it's probably no exaggeration to say that unconscious discrimination, unconscious bias is probably the commonest kind of complaint that we come across. So it'll start with, very often, a bad relationship of some kind, usually a management relationship, but it might be a relationship between colleagues of a similar level. And someone feels that they have been disadvantaged in some way. They might have had a hostile interaction with someone, or they're being managed more strictly than their colleagues or held to a higher standard, or they've raised complaints which haven't been understood. And they're looking for explanations for those things. Why am I being treated this way? Why has this happened to me? And sometimes, and I, as I say, speaking as an employment lawyer, I'm very conscious that we don't come across 90% of what goes on in workplaces. But sometimes the cases that come to us are about someone saying, well, I can't think of any other reason why I'm being treated this way. Is it because of my race or my gender or my sexual orientation, whatever else it might be? And the problem with that, of course, from the employer's point of view, is that if any discrimination is unconscious, then it won't be in the mind of the, let's say, the manager who's had this unfortunate interaction with the individual. It won't be in their mind that it's got anything to do with discrimination at all. And worse than that, if it's put to them that they have discriminated against this person, they are not unnaturally going to be hurt and upset and potentially offended and angry about that suggestion. And following on from that, there is a high likelihood that any kind of working relationship between the individual who's complained and the manager who they've complained against is going to break down. And the challenge for those of us who are managing these situations is to try and catch that situation before it gets out of hand, because the longer relationships are allowed to continue on a downward spiral, the more difficult it is to retrieve them. And the most difficult kinds of cases that we as employment lawyers get to manage are those where there is already an irretrievable relationship breakdown. And what we're really doing is trying to make the best of a bad job in retrieving the situation. But in reality, that relationship is going to have to be discontinued in some way, broken up, and someone is going to have to move elsewhere, and the two individuals are going to be separated. So if there is such a thing as unconscious discrimination, and I don't think there's really any debate about that, it's a pretty well established concept. Where does it come from? Now, those of you who've attended these sessions from us before will have seen the material on this slide before, and I'm just going to summarize it rather than go into it in the kind of detail that's been gone to my colleagues in previous years. But there's a number of different kind of biases which everyone has to some degree, which can explain discrimination, even though that discrimination isn't consciously on the basis of any kind of protected characteristic, but it's more to do with how we see ourselves and how we see others and how we relate to other people. So I'll just trot through these fairly quickly, just so that you understand basically what where this kind of behavior can come from. So this isn't any kind of complete list of biases, and all of these things are from academics and commentators who've written about these topics, but I think they are useful ways of thinking and understanding how discrimination can work in some situations. So starting with social comparison bias to start with, that's really about the tendency of all of us to categorize people into groups and make comparisons between them. And if you look at what people have written about the sociology of this, some people believe that this comes from a deep instinct in human nature, arising from our origins, if you like, as bands of family groups who would stick together for protection, and they would see their close relatives and families and near neighbors as their friends and allies, and everybody else being potentially hostile and dangerous. And it's that tendency to put people into those groups and take views about those groups that really forms this business about social, or this concept of social comparison bias. And once you start getting hold of this idea that that kind of bias might exist, you start seeing it everywhere, possibly misleadingly, but you can start looking at the way people behave and you think, maybe there's some of that going on. And that then leads us into the next kind of bias, which is very much related to that. So once you've got this tendency to categorize people into groups and take have opinions about those groups and have feelings about those groups, some of which you're in, some of which you're not in. Affinity bias is about your tendency to gravitate to people like us. And you will no doubt, if like me, you're afflicted with a certain amount of social awkwardness, and let's say who isn't to some degree. And if you go into a room that might be a party or a reception of some kind, or drinks after a work event, there's a room full of people, most of whom you don't know. You then you start looking around the room and you think, well, where should I go? What should I do? And you will tend to gravitate to people who kind of look as if they might be a bit like you. And that's a trivial example, but it operates much more widely than that. So people feel more comfortable talking to people or dealing with people who are a bit like them. And again, sometimes you're conscious of this, sometimes you're not, but you can see how that will look from the perspective of someone who is not like you and you're interacting with them. And unless you are mindful of your tendency towards affinity bias, they may come away with the impression that you've treated them differently because they're not like you, and you would have been warmer or more sympathetic to someone who was in your particular group, where and it might be on the basis of race or gender or anything else. So those two, I think, are probably the most important kinds of unconscious bias that we, rather paradoxically, we need to be aware of or thinking about when we're dealing with people, managing people, and trying to interpret concerns or complaints that might arise about discrimination. The last of these is probably less important in a discrimination sense, but it's still
what's this one? Line audio.
So it's still relevant in the sense that it's one of those ways in which we think that can be less than constructive when you're trying to view the world objectively and sensibly. So confirmation bias is the tendency to interpret the world in a way which endorses our own existing views. And very often this debate about confirmation bias comes up in the context of how we consume news these days, for example. So in the olden days, there was only one way to consume well, there were two ways of consuming news. You'd either read the newspaper or you'd switch the TV or the radio on. And there were relatively few channels through which you would get the news, and that all of that news was curated to some degree. So somebody was in charge of editing the news and presenting it to you in a certain way with a certain perspective. Nowadays, of course, that's completely different. So the news, people's experience of the news now doesn't come exclusively from the BBC or the Daily Telegraph or the Daily Mirror or wherever it might be. Most people get their news through social media and through all sorts of different media channels and websites, many of which now come with a point of view. And there's a lot of hand-wringing at the moment about the extent to which that is polarizing people's views about the way the world works. Because if you constantly see news that's being presented through a particular lens with a particular point of view, and that confirms what you always thought about the world anyway, then the suggestion is that you're going to go further and further down that rabbit hole and not look at the world with a more rounded and even-handed view. I think whether or not that's true, and if it is true, how long that's going to last for, they're all very interesting questions. But the underlying point about this is that confirmation bias seems to be quite a powerful way of explaining how people form their views and hold on to them, sometimes in spite of evidence to the contrary of them. So again, that's one of those things that's important to recognize both in yourselves and in other people. And when you're coming from an HR point of view, where everything I'm talking about in terms of the importance of equality, inclusion, and diversity in the workplace, that should all be second nature to you as HR people and to us as employment lawyers. That's not necessarily the way it's perceived in the world. So having a sense of how equality, diversity, and inclusion are perceived in your workforce and what you can do to improve that perception is something that we all need to be mindful of. Right, so that's the background to all this. I'm now going to talk a little bit more about the legal ways in which equality, diversity, and inclusion is managed. So just a little bit of revision before we get into some of the more nitty-gritty issues. So discrimination law used to consist of a range of different statutes and regulations dealing with race discrimination, sex discrimination, and disability discrimination, and various other areas separately. Most of the law has now been rolled up into the Equality Act in 2010. And the Equality Act defines a range of protected characteristics, which are down there on the left-hand side of that slide. So individuals with those protected characteristics can claim that they've been discriminated against in a range of different ways on the right-hand side of the slide, and we're going to go and explain which of those is what they mean, first of all, but also which of them are most relevant in your workplace. So when I was starting out in employment law, there was a Race Relations Act, there was a Sex Discrimination Act, and there was some protection against marriage and civil partnership and pregnancy and maternity. But there was no such thing as the Disability Discrimination Act or the protections that disability now enjoys under the Equality Act. Gender reassignment, no one had heard of. Religion or belief was not protected, neither was sexual orientation. So all of these things are actually relatively recent, and I think it's safe to say that the world of work is still, to some extent, dealing with how these things are managed in the workplace. So those aspects of discrimination that have been well entrenched, like race and sex, for example, are now so well understood that they tend to be easier to manage in the workplace. And it tends to be the newer kinds of discrimination where sometimes it's difficult to understand precisely what someone's protected characteristic is and how that's affecting them in the workplace, and then how it should be managed. Those tend to create the more difficult questions. Which is not to say that race and sex discrimination and those more long-established ones don't still come up. They absolutely do. But I think conceptually we understand how to manage those in some ways better than we do with, for example, religion or belief, which, as you might have seen if you've been following any of the case law in this, throws up all sorts of difficult issues about definition, for example, of what kind of religion or what kind of philosophical beliefs are protected by religion or belief discrimination. So let's have a little look at the types of discrimination in a bit more detail. So direct discrimination is probably the one that if you asked someone in the street who wasn't an HR person or an employment lawyer, what's meant by discrimination? They would say, well, if someone's of a particular race and you treat them badly because of their race, then that's discrimination. And that's really what direct discrimination is. It's where someone suffers a detriment because of their protected characteristic. The reason for the treatment is the protected characteristic. But as we've seen, and is obvious from this slide, the actual position is a little bit more complicated than that. So we'll go through just again quite quickly explaining the types of discrimination and what they mean in employment law terms. So direct discrimination, as I say, is the simplest one. Indirect discrimination is much more difficult for most people to get their heads around. Indirect discrimination consists of applying a discriminatory provision, criterion, or practice which discriminates against people with a protected characteristic. And I always find that the easiest way of explaining what indirect discrimination is to use an example. And probably the easiest example that people will be familiar with is equal pay cases, which are a bit like, they're not exactly the same as indirect discrimination, but the principles are the same. So you will have come across all of the equal pay cases that are going on now in the supermarket sector. So the Asda equal pay claims have now been going on for years, and there are a number of other supermarkets that are now facing the same sort of thing. And these claims are essentially all the same in terms of the individuals who are bringing the claims, their comparators, and how the claims are being managed. And they essentially arise from this issue, which is that people who work in stores for these retailers are predominantly female, whereas people who work in the warehouses and the distribution side of the businesses are predominantly male. And for largely historical reasons, the people who work in the distribution network are paid better than the people who work in stores. Now, why can't they claim, why can't the women who work in stores claim direct discrimination? The reason why they can't claim direct discrimination is because they're not paid differently because they are women. They're paid differently because they work in stores in a different job. But they can claim equal pay because although the reason for the difference in pay is not the fact that they are women, the statistics show that it's women who are mainly disadvantaged by that difference in pay, and it's men who are advantaged by it. And so it's not directly related to sex, but it's indirectly related to it, and therefore it's an indirect discrimination claim. Another example, which is a bit more trivial, is that, and I never know really whether this is an urban myth or not, but there's, it's commonly believed, and I've never actually been bothered to look this up, that in the olden days, if you wanted to join the police force, you had to be 6 feet tall. I don't know whether that's true or not, but I'm going to pretend that it is for the purpose of this illustration. So if that was still the case, and I'm certain that it isn't now, you can see that that requirement to be 6 feet tall isn't directly discriminatory in respect of any protected characteristic. But because it's much more likely that men will be 6 feet tall than women will, it would be indirectly discriminatory against women. So that's another example of an indirect discrimination argument. It may be I'm laboring this point too much, but it's important that you understand what indirect discrimination is, because it's one of the more litigated kinds of discrimination in practice. So let's look at harassment. And you will often find that in terms of the legal claims we face, harassment comes up very often as in conjunction with another kind of claim, which might be direct discrimination or victimization or some other kind of discrimination. So harassment is really about creating an environment which is hostile, degrading, humiliating, or offensive, which is related in some way to a person's protected characteristic. And the way this often comes up in practice is where someone starts to believe that they are being discriminated against because of their protected characteristic for some reason. So it might be an individual who thinks they are getting a harder time from their manager in terms of performance management, perhaps, than their colleagues are, and they might say, well, it's because I'm the only person from an Afro-Caribbean background in this workplace, and I think that's the reason why I'm being treated that way. If they were right about that, that would be direct discrimination. But as time goes by, and if there is a consistent pattern of this behavior of that person being treated differently, then they might start to feel that a difficult environment is being created by that treatment, and therefore they could claim harassment. Victimization tends to arise from situations like the one we've just talked about. So if someone does feel that they've been discriminated against and perhaps harassed in the workplace, they might then complain about it. And victimization is about what happens next. So if someone does complain about it, that's called a protected act under the Equality Act. In other words, complaining about potential victimization. That's not the only kind of protected act, but it's the commonest. Someone complains about about discrimination and is then subject to some kind of detriment because they've complained, then that's victimization under the law, and that's a separate kind of discrimination. And again, when you get these cases deriving from relationship breakdowns, people will very often have complained, and they'll often feel that their treatment has then changed after their complaint to their detriment, and they'll say, I'm now being victimized as well. I'm not going to go really very much into this next heading, which is about the liability of third parties other than the employer, but just suffice to say that other people who might be involved in the discriminatory conduct that's being complained about can also be liable. Where this arises most often, in fact, is if someone believes that they've been discriminated against by a colleague at work and they bring an employment tribunal claim, they will claim against their employer because their employer will be liable for discrimination in the workplace, but they might also complain against the individual who has discriminated against them, might be their manager or somebody else. And it's important to understand that that individual person is jointly and severally liable for any compensation that that person might recover in the employment tribunal if they win their claim. And that can create all sorts of difficulties in managing the claim. And of course, the individual who's been named as a respondent in person is going to be acutely anxious about that, which is probably the reason why they were named in the first place. And managing how that claim should be dealt with from that point can be a tricky issue. I've included disability discrimination, which is not technically a kind of discrimination. Obviously it's discrimination relating to a particular protected characteristic. But the reason why I've included it separately on this list is there are some kinds of discrimination which only relate to disability. There are two of them, and the first one is, and this is the wording from the statute, unfavorable treatment because of something arising in consequence of disability. Which probably takes a couple of readings before you understand what it's getting at. But what that means is it's a little bit like indirect discrimination. Suppose you have an employee who is not performing, or their attendance at work is below the standard at which you would normally start managing it. And you begin the process of managing their performance or their attendance. And it emerges at some point, or you might even have known from the outset, it emerges that they're a disabled person. And the reason why their performance or their attendance is below par is related to their disability in some way. Now, in managing their performance or their attendance, you're not discriminating them because of their disability, but because of something arising in consequence of it. So that's the subtle difference between direct discrimination on the basis of disability and this unfavorable treatment because of something arising ahead of disability. The crucial difference between direct discrimination and this something arising discrimination is that direct discrimination can never be justified. So if you treat someone unfavorably because of their race, there is no defensive justification for that. There's no good reason why you should discriminate against someone on grounds of their race. But there can be a good reason why you would treat someone less favorably because of their attendance or their performance, even though that performance is related to their disability. So you can justify managing someone with a disability, but your management of them has to be proportionate, and it has to satisfy a real business need to address their attendance or performance. And that can be quite tricky in practice, and tribunals are sometimes quite insistent on making you define precisely what your justification defense is if you're going to manage someone who's clearly struggling because of a disability. Which then brings us on to the second point, which is another unique feature of disability discrimination, and that's the duty to make reasonable adjustments, which I'm sure you're all familiar with. The important issue about reasonable adjustments, and the one which we see as being problematic in lots of the cases that we deal with for employers, is that if you have not properly addressed your duty to make reasonable adjustments, and essentially you've made any adjustments which are reasonable, then any attempt you make to manage a person's performance or attendance at work is likely to be doomed to failure in terms of being discriminatory, because if that person needed adjustment to be made and you haven't made it, then you're not going to be able to manage them reasonably and in a non-discriminatory way. So it's really important that you treat those two areas of discrimination as being in combination with each other. All right, so which of these kind of discriminations do we see as lawyers most often in practice? So I'm going to go through some of these. Direct discrimination, so it's discrimination because of the protected characteristic, arise most often in these sort of situations. Probably the commonest, I think, in terms of the claims we get is to do with a management relationship which is broken down. So someone believes that they're being managed harshly or unfairly, and in default of an explanation which they can understand, they think, well, is it because of a protected characteristic which I have? So my manager's taken against me because of my race or my sexual orientation or whatever. And those things can take the form of bullying or robust performance or absence management, disciplinaries and that kind of thing. Or they can be discrete decisions about promotion or other benefits. And the difficulty we have, and this is going back to the slides that we looked at the top of this presentation, is that these things are all about perception. And very often in a direct discrimination case, in fact, almost invariably these days, there isn't any evidence of someone saying, I don't like you because of your race or because of your sexual orientation. There is just treatment, which the individual who's being treated in that way can't explain or doesn't want to confront the explanation by in any other way than that it's because of their protected characteristic. So they will say, I know you, my manager, is saying I'm a poor performer or whatever else, but I think it's just because I'm from this particular ethnic group or whatever. And because of the importance of perception in these cases, proving a case one way or another becomes very difficult. And we'll talk later on about how the burden of proof works in these kinds of cases. Harassment's the same, and as I say, very often when you get cases, direct discrimination and harassment often come side by side, and harassment is this issue about creating an environment, a discriminatory environment, which is intimidating, hostile, degrading, humiliating, or offensive. Most often these kinds of claims will come from a relationship that's broken down. It'll be described as bullying and harassment. And again, in the same way that no one, or at least it's very rare that people intend to discriminate, it's very rare that anyone intends to bully and harass anybody. But of course, bullying and harassment is, to a degree at any rate, a matter of perception. So from the manager's point of view, they may well be managing someone robustly but fairly, but from the individual's point of view, they're being harassed because they're doing their best and nothing's good enough for the manager. And most of the time, by the time these cases come to us, the prospect of getting those relationships back on the rails has probably long since gone. But the challenge for you in HR, if that's not the case, and very often we're told that it is, by the time the case gets to HR, it's so far down the road that the relationship is irretrievable. But if it does get to you in time for you to be able to take some steps to resolve the situation by mediation or some other similar sort of route, it's very often worth putting as much time as you can spare into that that kind of non-formal relationship building. I can't really tell you. You probably have a much better idea between you than I do about how often that's successful. I have to say I'm a little bit gloomy about it, but that's because the cases that reach my desk tend to be the ones where that's been tried and has failed. So I tend to see through the lens of something that doesn't work very often, but you might tell me that actually, if you get in early enough, it is effective at resolving at least some of these concerns. Once you get into the territory of someone being perceived as a troublemaker, if they raise concerns about their treatment, then you really are in difficulties, because not only is that harassment, but it might get us into the next, actually, I may have skipped the slide, but it might get us into the area of victimization as well, which, if you remember, is being subject to a detriment because you've raised concerns about your treatment and suggested that it might be something to do with discrimination. Disability discrimination, I think, is probably the commonest kind of discrimination that we see in practice as employment lawyers. And I think the reason for that is that disability discrimination cases often arise in circumstances where someone's performance or their attendance is being managed. So it's ostensibly, at least, and from the origin of it, it's nothing to do with a relationship breakdown or anything personal relating to the employee. It's just about a perfectly legitimate requirement by the employer to manage their attendance or performance. And where you get into difficulties of disability discrimination are really in two areas. The first one is whether the management's reaction to the individual's performance deficit or poor attendance is proportionate. So if you remember, this is the kind of discrimination where it's a detriment arising, because of something arising in consequence of the disability. And the guiding principle behind that is that your treatment of that individual has to be proportionate, which is a bit like reasonable. It's not quite the same test, but it's reasonable. So you need to think about the discriminatory effect of what you're doing and balance that against the management need, for example, to manage attendance or performance. That's what proportionality is about. It's about this balancing exercise. So sometimes employers struggle to get that proportionality quite right. And the other thing, which is possibly more prevalent than that still, is about the management of the medical input into the situation. And probably the commonest problem that we come across with managing the medical input is that employers don't think hard enough about how to seek occupational health advice and other medical support. So very often they'll write a standard letter to the occupational health advisor saying, we've got this individual, they're not attending work, can you please assess them and see whether they meet the definition of disability in the Equality Act, and can you advise us about any reasonable adjustments that might be necessary if they do. And you'll get a reply back from the occupational health advisor which says, yeah, I think they probably do fall within the Equality Act and they might benefit from these adjustments. The problem with that is that depending on the kind of conversation that you've had with your occupational health advisor, you do need to understand that their advice about reasonable adjustments is coming from a pretty narrow base of knowledge, unless you've done something like a workplace assessment in which the occupational health advisor has been involved, or you've got some other kind of external or possibly internal advice about what it is that the employee is struggling with and what the options might be for dealing with them. And I guess the take-home message from it is that the occupational health advisor is not necessarily the best authority on what is a reasonable adjustment. So they're usually very good at telling you what the employee would find helpful, but whether that's reasonable and whether it's the only thing that might help them is something that you probably need to give some more thought to. And generally speaking, that's why these claims often go off the rails. Okay, so the situations in which these kinds of discrimination can arise are, and again, from our caseload, recruitment, obviously, if we're making decisions which have an effect on someone which relates to their protected characteristic, that can be difficult. Most employers now are, and especially in the NHS, are really very careful about this. And we don't tend to see an awful lot of recruitment cases, except with one kind of case that we see relatively often, and that's about references. And so the commonest kind of case where this arises is where you have conducted the interviews, you've accepted someone subject to references, and the reference comes in from their previous employer, which says they were a perfectly good employee whilst they were here, but their attendance record was poor, and they only attended 110 days in the last year or whatever it might be. And on the basis of that reference, you then reject their application. And the individual looking at this says, well, that is an unfair reference, because in fact the reason why I was absent during that time was because of a disability which necessitated my absence, and my previous year's absences were perfectly acceptable, and therefore that reference is not sufficiently balanced, it's discriminatory and unfair. And of course, as the employer who's received that reference and relied on it, there will be a question about whether you're liable for disability discrimination if you haven't asked the right questions. But certainly the employer who's given the reference is likely to be in trouble if the employee then complains of disability discrimination. In terms of other kinds of discrimination, which might be race or sex or various other protected characteristics, they are most often to do with poor management relationships. So it's managers who are not proficient at dealing with poor performers, poor attenders, and just managing people generally in a way which avoids discrimination. Inequalities in banding and pay we see quite often. Obviously, the fact that in the NHS we have the Agenda for Change job evaluation and pay banding system, that has reduced a lot of the concerns about equal pay and various things, but you will still see arguments about the pay points on in which people end up, and also the banding of particular jobs which people may perceive to be the same but are banded differently for various reasons, some of which are good and some of which are not so good. Lack of clarity in communication is a perennial bugbear in terms of discrimination claims, and I think that that cuts both ways really. So communication can be a bit tin-eared in the sense of if you are going to send out a communication to your workforce, before you press send on your email or whatever it is you're going to send, obviously you need to read it from the perspective of the person who's sending it. But that skill of trying to read that document from the perspective of someone who is seeing it for the first time and is going to be affected by it is really valuable. And the sense we get, again, from our perspective, is that sometimes you'll see communications which have been sent out in workplaces where it's not clear that that sense checking exercise has been carried out before the communication's been sent out. And that can then create all sorts of misunderstandings and sometimes some offense. The other issue about communication is almost the opposite of that, which is where HR or some other function within the organization is trying to send a message which they are concerned might be perceived by some people to be not offensive, but a difficult message. And in order to try and avoid that difficulty, they'll draft the email or the message in such a way that it becomes almost impossible to figure out exactly what's being said. So if you want to sort of headline that, it's try and call a spade if you can. Clearly you'll need to be a bit more polished than that, but it's don't let nervousness about the reception of the message get in the way of conveying whatever message you're trying to convey clearly. And sometimes we've seen claims of discrimination which arise from a message which is perfectly well intentioned, but has been misunderstood because no one understands what it means. So do be careful about that. Formal capability of conduct procedures, you can, again, speaks for itself. That's really about someone perceiving that the reason why they're being taken through these procedures is because of a protected characteristic, rather than any genuine belief by the employer that these things are a real concern. And lastly, and not surprisingly again, organizational change and how people are treated in redundancy selection and other and redeployment in consequence of organizational change. If someone doesn't understand why they've been made redundant or why they haven't been selected for a particular job, sometimes that comes down to the effectiveness of the communication with them, but sometimes they will simply want to understand whether it's got something to do with a protected characteristic, and a claim might arise. All right, so a little bit about discrimination claims in the employment tribunal and how they arise. So first of all, who can claim in the employment tribunal? And clearly the most obvious category of employees from, category of claimants from your point of view are employees, but most of you will be aware that the definition of employees is wider in the Equality Act than it is, for example, in the Employment Rights Act, which deals with things like unfair dismissal. So under the Equality Act, employees and other workers can claim discrimination, and that definition of workers includes agency workers and contract workers and officers, including, for example, your non-executive directors. So you just need to be aware that other categories besides employees can bring employment tribunal claims for discrimination. As we've touched on earlier on, claims will usually be brought against the employer, but in discrimination claims and also in whistleblowing claims, by the way, individual respondents can be named as individual discriminators, and they can, in principle, be separately liable for any compensation. And I'll explain a little bit about how that works at the end of this slide. Employers, so in a claim where an individual might claim discrimination arising from behavior of their, let's say, their manager, the employer is going to be vicariously liable for the conduct of their manager. And vicariously liable means even though it was the manager who did the deed, the employer is deemed in law to be legally liable for that discrimination if it is discriminatory. That only applies, and this is really crucial and does sometimes come up in cases, only applies if the employee is acting in the course of their employment. So I'll give you an illustration of what that means, because we've just had a case on this in our team. So an employee of a trust had an altercation with their full-time union official. And the altercation was about the fact that this individual had asked for his union membership to be cancelled so he could join another union. And he'd been asking for this for quite some time. And ultimately, because he wasn't getting what he wanted, during a work break, he went into the office of this union and spoke to the union official, and a bit of an altercation took place, during which he was alleged to have racially abused the union official. The union official then brought a claim against the trust and against the employee who had allegedly racially abused him. And the question for the employment tribunal was whether the individual who'd allegedly racially abused the union official was acting in the course of his employment. And what made it difficult in this case was that when this all came about and the union official had complained to the trust about this racial abuse, the trust had then carried out a disciplinary process relating to the alleged discriminator, and it dismissed him for gross misconduct. And you might say that having done that, it was going to be in difficulties arguing that even though it had dismissed him, it didn't accept that that discrimination took place in the course of his employment. Because you could say, well, if it's not in the course of his employment, what business is it of yours? Why would you dismiss him? But regardless of that difficulty, and because we had a good barrister, we were able to successfully argue that, in fact, because the altercation took place in the individual's break time, and because it took place in the union office, and because it was about union membership rather than anything to do with his employment, it was not in the course of his employment, and the tribunal accepted that argument. So it's a tricky issue, and most of the time, in fact, it's not really an issue at all. So anything that happens in the course of a management relationship, for example, will of course necessarily be in the course of their employment. It's also important to note that agents acting with the employer's authority can give rise to liability for the employer. So if you've got, for example, contractors on your site, or locum doctors or agency staff or anything like that, if they are behaving in a way which is sanctioned by you, obviously the discrimination won't be sanctioned by you, but that they will be interacting with your staff in a way which is sanctioned by you, and then during the course of that they discriminate, then you can in principle be liable for that as an employer as well. Recruitment cases we've already mentioned. The former employer and the recruiting employer might be liable depending on the factual background in the case. What's weird about these cases where more than one respondent can be liable for the discrimination is that this liability is described as joint and several, which I mentioned in the last slide. You're probably wondering what I was on about. Joint and several liability is a very strange concept, and essentially what it means is that if someone brings a claim against both the employer and their manager, for example, then the tribunal will hear the case and it will decide whether either or both the employer and the manager are liable. If it decides that both the employer and the manager are liable and awards compensation, what joint and several liability means is that the claimant can claim the full amount of the damages from either the manager or the trust, and it's completely a free choice for them, which is a very strange outcome from the perspective of the parties to the claim, but that's what joint and several liability means. So if you are involved in one of those claims where there are multiple respondents, it's something to bear in mind in terms of managing how the claim is dealt with your lawyers and generally. Okay. One of the trickier issues about discrimination is how an employment tribunal goes about establishing whether discrimination is proved. And the reason why this is difficult is an issue which has arisen in case law from as long ago as discrimination was first came up. And it's this idea that discrimination is very seldom overt. So of course there are cases of direct racial abuse which is targeted at the particular protected characteristic, but most cases arise where someone is being treated in a way which they think is detrimental. They don't understand why, but their best explanation as far as they're concerned is that it's something to do with a protected characteristic. And so they will put that claim into the tribunal, and the response from their employer will be, let's say that they accept that the detrimental treatment took place. They will say it was nothing to do with their race or their sex or whatever. It was to do with their performance or their behavior or whatever else it might be. And so the employment tribunal has to choose between these two alternative explanations of the discrimination or the alleged discriminatory behavior. And the way it goes about it under the current state of the case law, and it's now enshrined in the Equality Act as well, is to carry out what's usually described as a two-stage test, although it's not quite the way most tribunals will apply it, but it's broadly a test in these two stages. First of all, it's got to decide whether there are facts, and those facts really need to be proved by the claimant on the balance of probability, whether there are facts that, ignoring the explanation from the employer for the moment, they could conclude that the claimant was discriminated against. So an example of that might be, let's say an individual from an ethnic minority group was complaining about their treatment by their manager. And they said, well, actually, it's not just me. All of the Sikhs in this group are treated the same way by this manager because he doesn't like Sikhs. And that, if this employee is able to make out that that allegation, so is able to demonstrate that that's true, then the tribunal is going to say, well, yeah, it looks like there's something going on here. That looks like a discriminatory course of conduct, and so I'm going to go to the employer now, and it's for the employer then to prove that actually it's not discriminatory. And the reason why it might be perceived that Sikhs are treated in this particular way is because of some other reason that isn't discriminatory. So that's the two-stage test. First, the claimant has to establish that there's something fishy going on, and then the employer has to show that even though it looks fishy, it actually isn't, because the real reason is something else that's not discriminatory. As I say, tribunals don't apply that two-stage test quite as rigidly as that in hearings very often, but the logic of their decision making has to follow that model. All right. Let's look at positive discrimination. And we very often get questions about this to do with recruitment, where an employer is, for all the right reasons, trying to address the balance of their workforce, whether to do with race or gender or some other kind of protected characteristics. So they're seeking to improve diversity in organizations, all those good things we were talking about at the start of this session. And the question is, how far can you go in seeking to recruit people from a particular ethnic minority, for example? And generally speaking, positive discrimination, however well-intentioned, is unlawful if the result of that positive discrimination is that you're treating one employee more favorably than another, or one job applicant more favorably than another job applicant, because they have a protected characteristic. And remember that race is a protected characteristic, even if you're a white British person. If you're a white British straight male person, all of those characteristics are protected under the Act. So the furthest you can go in job adverts is encouraging applications from particular minorities if they are underrepresented in your workforce. That's as far as you can go, but it needs to be absolutely clear that you will treat those applications when they're received in the same way as everybody else is. But you're just encouraging people to apply, that's fine. So there is very limited scope in the Equality Act for positive action. And we've listed those instances in this slide. So if a particular characteristic is an occupational requirement of the work, used to be called a genuine occupational requirement, but there's no longer called that, then you can recruit someone. For example, if you run an Indian restaurant, it's widely accepted that you can recruit people from the South Asian subcontinent if for authenticity purposes, in terms of the staff in the restaurant. It's really pretty rare. Certainly in healthcare, it's extremely rare. The only area I think where I've come across that in healthcare is in mental health organizations, where mental health trusts, where you have some service users who, for example, might have an irrational aversion to men or women or people of various different racial backgrounds. And for therapeutic reasons, it's just not sensible to ask someone from an ethnic minority to go in and look after that person. So you might have to choose a white male person or a white female person to go and do that job. And that is very likely to be deemed as an occupational requirement just because of the therapeutic needs of the individual, but it will be rare. So the other kind of positive action which is available is this proportionate action which you can take to encourage people from protected characteristics to overcome a disadvantage. So if you conduct your recruitment exercise and you get a bunch of CVs in to have a look at, and you boil it down to a white British candidate and an ethnic minority candidate, for example, they are equally qualified. That's very important. But you know that ethnic minority staff are underrepresented in your workforce, then it's legitimate as a tiebreaker to use that underrepresentation as a reason for recruiting the person from the ethnic minority. That is lawful, of course, but we have seen a cases, not very many, but we've seen a few cases where it's been challenged by the white British candidate who then loses out, who says, you have only chosen this other person because they are brown, and that's direct discrimination. So whenever you make that kind of decision, you need to be pretty confident that you can justify your decision and that your assessment that both candidates were equally qualified is robust. So you just be very careful that you've gone through the application documents with a fine-tooth comb and the interview notes and everything else, and are satisfied that they were on an equal footing before you make that decision. Disability discrimination is different for two reasons. First of all, this obligation that you have as an employer to make reasonable adjustments to assist a disabled person who's at a disadvantage in the workplace is effectively positive discrimination against or in favor of disabled people. Of course, they might argue that because they're otherwise at a disadvantage, it's not really positive discrimination at all, but that's another argument. But more fundamentally, in terms of disability, there is no prohibition on treating disability or people with disabilities more favorably than people without disabilities. So in other words, not having a disability is not a protected characteristic, which is kind of obvious, but sometimes it's quite startling when you see that written down. All right. So let's look at reasonable adjustments. I'm going to go through these relatively swiftly because I want to leave a bit of time for questions at the end if anyone's got any. Reasonable adjustment cases in disability discrimination are probably the commonest kind of discrimination claims that we get of all the different types of discrimination. Disability is the most frequent when it comes to claims that we see, and in almost every one of those disability discrimination cases, it's the question of reasonable adjustments that causes the problems. So a few tips then on this slide for how to manage that issue. The first one is what kind of assessment you make of the situation. So a need has arisen of some kind, whether you've just recruited an employee with a disability, or whether an employee has developed a disability, or some other circumstances have changed. But you then need to figure out what effect their disability has on their ability to carry out their job, and what adjustments might be reasonable to help them. Depending on what kind of issue they have, it can be really helpful and a powerful way of demonstrating that you're taking the issue seriously to conduct a workplace assessment with them. Very much depends on what the disability is and what their difficulties are. But carrying out a workplace assessment with occupational health so that, first of all, you are seen as the employer to be taking the issue seriously and consulting the individual carefully about the issue, and involving OH so that OH is properly informed about the issue as well at an early stage. That's a really powerful way of starting out to manage these issues. Consultation, which is important in so many areas of employment law, is particularly important here. So there is a tendency which creates difficulties by HR or by managers or both to treat reasonable adjustments as a problem that they have to solve. So once the concern has come to light, managers and HR people sometimes get together and say, well, we need to do this, we need to do that, and let's do this and let's do that. And many cases arise because the individual with a disability is not being consulted or not being consulted enough about the proposed resolutions, whether they'll work or not, what kind of trial they might need to see whether they're going to work, and that kind of thing. So as much as you can consult with the individual, the better it will, the outcome is likely to be. And on that point as well, occupational health, if you do that kind of standard letter of occupational health where you say, please tell us whether the individual has a disability and also what reasonable adjustments might be helpful, you have to understand what the advice that you get back is going to be based on, and it'll be based on what the individual has told the occupational health advisor and what the occupational health advisor's perspective on this is. And if you haven't done a workplace assessment so that the OH advisor understands the position clearly and in detail, you need to be quite careful about whether the advice you get back from the occupational health advisor about reasonable adjustments is reliable. In other words, whether they've considered all the adjustments and whether what they're recommending is reasonable and helpful. So do bear in mind the need sometimes to carry out some more inquiries when you get that occupational health advice. Although this is probably less of an issue, this next point in the NHS, because you tend to manage these things very well internally, in some cases it's still worthwhile thinking about what external advice and support you can get from outside organizations, charities, and what have you. Sometimes they can be very helpful, and if you have particularly expensive adjustments to make, sometimes they will contribute, although they're very often less willing to do that in the public sector, it has to be said. Timescales are perhaps one of the commonest reasons why these reasonable adjustment cases go wrong. And I know how difficult it is to manage a whole range of caseloads as an HR practitioner, but most of the issues that we get with disability discrimination are where a reasonable adjustment has been identified and the individual's been told this is happening, and then it doesn't take place for a very long time. And it won't be the fault of the manager, it won't necessarily be the fault of the HR person. It's likely to be some kind of procurement issue, or some adjustment needs to be made in the estates department. But it's really important that you keep on top of progress with that, and again, crucially, communicate clearly and often and effectively with the individual. And in doing that and keeping the individual on side, you're much better placed to try and reduce the risk of a claim. There will very often be adjustments which have been requested by the individual which you can't provide or can't provide in the way that they want. So again, that consultation and involvement of occupational health is important in trying to identify what alternatives might be available and trying to arrive at a reasonable alternative solution. So those are the kind of the main areas that we see in disability discrimination claims. More widely, and again, this is still it relates to disability and everything else, but more widely in discrimination claims, the problems that we see in our caseload arise from some of the issues that are on this slide. So if someone complains about disability, and again, this sounds completely obvious and almost insulting that I'd put this down as a piece of legal advice, but you'd be astonished how often it happens that a complaint has been made, and when it's been reflected back to the individual as, you know, you've complained about this, that letter doesn't accurately capture what the individual is complaining about. So it's really important when you are, you know, if you're involved at the first stage of one of these things, reflecting what's being said to you back at the individual and saying, can I just make sure I've captured this accurately? What you're saying is such and such and such and such. And by the time they receive something in writing, they're not immediately on the defensive because what's been put down in writing is not an accurate reflection of what they're complaining about. Again, sounds obvious, but you'd be surprised how often that goes wrong. Most of your policies and procedures, whether they're to do with grievances or anything else, involve exploring informal options for resolving complaints before you go through any formal route. And that's absolutely right that you should do that, but you do need to be realistic about this. And the reason I say that is because by the time someone has summoned up the courage, and it does involve quite a lot of courage to come forward with a formal complaint, our experience is that trying then to deal with that as an informal issue between them and their manager, whoever else it might be, at the time for that has often passed. That's not always the case, but and you should certainly raise it as your first port of call. Can we deal with this? Can we have a conversation about this? Can we mediate it in some way? But our advice is, yes, you should promote that, but don't try and push it further than the employee wants to go. Because if all the evidence is that they've struggled with this for a long time and they've come to you in desperation, then an informal route is less likely to be helpful. Once, when you're dealing with a complaint and you've captured exactly what it is, you can explain the options, informal and formal, to the individual. And crucially, you need to explain that to some extent, you're going to have to discuss this issue with the alleged discriminator. And again, that might lead to a difficult conversation, but clearly, if the complaint is going to be investigated, then the discriminator is going to need to be spoken to. But you'd be surprised how often that the person raising the complaint becomes uncomfortable when that prospect is raised. So you need to deal with that with them and make sure they're reassured that they will be protected against any consequences that might arise from that conversation. Once we have got past that stage and we're getting into an investigation into the allegation of discrimination, you need to be careful to consider the options of dealing with the alleged discriminator whilst the complaint's being investigated. And there are a number of issues with this, but probably the commonest arising that we see is that investigations, particularly into a long and complex history of alleged discrimination involving a lot of people and a lot of correspondence and whatnot, they can take a long time. So first of all, again, obvious point, if you're the HR manager involved in managing these things, you need to be in charge of timeliness. And so many of these cases go wrong because the individual begins to perceive after a period of time that their complaint isn't being taken seriously, or it's being swept under the carpet or whatever else. And once that perception arises, it's very difficult to retrieve the situation. So again, do keep them informed, but at the same time, you need to consider what to do with the alleged discriminator. So if you're in if the complaint has arisen in the context of a management relationship, for example, how do you deal with that relationship? And obviously the possibilities might involve redeployment, or on a temporary basis, or someone might need to be suspended for a long period. All of the options are there, but you need to be, again, once you've made those decisions, they need to be constantly reviewed and people need to be reassured that progress is being made. Again, it's probably slightly hammering the same point too much, but it is a really common problem. When you appoint the investigator, everyone in the NHS, it's probably a bit of a broad sweeping generalization, but most people in the NHS are already busy enough, thank you very much. So if you appoint an investigator, they will have a day job, and you need to make sure that they do have time to actually conduct this investigation as well. And that might involve a conversation between your manager and the investigator's manager to give them some protected time to actually do the investigation and to write the report. Because again, time is your enemy very much in this process. The longer these things take, the more positions get entrenched and the more difficult it is to resolve them. And very lastly, last point on the last slide, is communicate clearly and unambiguously. And I know how difficult this is, but where organizations often fall into error is in not being courageous enough to communicate an unpalatable message clearly in communications. So do try when you're communicating to make sure that however delicately you're trying to express something, you do end up saying what you mean clearly. Call a spade if you like, but do try and make sure that your communications can't be misunderstood as being less serious than you intend them to be, and that they mean exactly what you intend them to mean. Again, an obvious point, but we see this organizations falling foul of this very, very often. So I feel I've been rambling for quite long enough now, and we're nearly coming up to the end of time. So has anyone got any questions before we close? So what I'm not doing is looking in a chat box. So if anyone's asking questions on the chat box, I'm afraid that's not going to be very helpful, because hang on, let me have a look at that. There's 17 questions in the chat box, in fact. Here we go. If anyone is on mute and wants to raise a question, which they haven't raised so far. So where does positive discrimination come into this? Well, fortunately, I've dealt with that one, so good. Have we had any claims regarding staff being able to wear masks in an NHS clinical session? That's a really good question. There are two issues about that, about masks in particular. One is a specific one which relates to Sikh men who, as you will know, are forbidden to cut their hair, including their beards. And so there is a question about whether you can, whether effective PPE can be found for them, because a normal mask that you would wear in a clinical setting won't be effective for someone wearing a beard. So I understand that there is a workaround for that, but that's something you need to be culturally sensitive to. More commonly, you will get people who, for various clinical reasons, can have breathing difficulties or other difficulties wearing a mask. And the question is, can you then, or should you then, permit that person to go into a clinical setting where people might be at risk without wearing a mask? There are two aspects to that question, one of which is clinical, which I'm absolutely not capable of answering, and the other one is to do with employment law, but they do relate to each other, and they relate to each other in this way. First of all, you need to establish what the risks would be from a clinical point of view if that person entered a particular area without wearing a mask. And of course, there's this balance, isn't there, between what masks do for you in protecting you, and also what they do if you're infected in protecting everyone else. And we're really concerned with both of those things here. So whether you can, as a conscientious employer, permit someone to go into an area where they might be exposed to COVID or whatever else without a mask, but also the risk that they present to other people if they're if they might have COVID. So it's a complex question. It'll be to do with your testing regime. Do you test people every day? But knowing, of course, that you could be infected before you start testing positive. All of those questions are relevant. But the real answer to the question is, and I'm afraid it's not very helpful, but it's the only answer I can give, because it really is the only correct answer, is that it's what's reasonable in the circumstances, and the circumstances will be different in every single case. You should, and generally speaking, must err on the side of safety. So if it's not possible to allow the person to work in a clinical area because they can't wear a mask, then you must find them something else to do or send them home if there's a clear safety issue. If there isn't and you're confident about that, then potentially you could, but that is the fundamental issue. Right, let me see if there's anything else. I always find these sessions a bit spooky when I'm not actually having people asking me questions. So the positive discrimination, excellent, we've done that. Everyone's being very kind in these comments, which is very nice to hear. So if anyone has got anything, so someone's asked a question about neurodiversity. Yes, that absolutely does come into this, but there is no particular category. There is no discrete category of discrimination which relates to neurodiversity. So if you are neurodiverse, for want of a better term, the question from a discrimination point of view is whether that neurodiversity is such that it amounts to a disability. So does it cause you a substantial disadvantage in terms of your ability to carry out day-to-day activities? If it does, it will be. But it depends on the effect it has on you. That I think is all the questions that there were. So unless anyone's got any others, thank you very much for your attention. Thank you very much for your kind words. If you put any kind words down in the comments, and goodbye.